Now moving ahead to another important term, that is called manager. Manager is defined, and it is very significant. The definition, if you read, it says an individual. So it is a person, it is an individual who, subject to the superintendence, control and direction of the board of directors, has the management of the whole or substantially the whole of the affairs of the company. And it is important to note here that what matters is not a person is described as a manager, but what he is exercising substantial part of powers of a management. It is very important to note here. So there are three important things which we are noting: that he must be an individual, it cannot be a company, firm or other things, and he is subject to superintendence, control and direction of the board of directors. So he cannot act independently on its own, it has to be always under the superintendence, control and direction of the board of directors. And thirdly, that he has the management of whole or substantially the whole of the affairs of the company. What does it mean? It means that he is the whole soul in charge. Accordingly, a shop manager or a factory manager cannot be a manager under the Act. There is no need that manager must be an employee of the company. So there is no specific need, but he must be an individual, he must have substantially the whole management of the affairs of a company and must be acting under the superintendence, control and direction of the board. Now, I have already pointed out that it cannot be a firm or a body corporate or association of person, and here we refer to section 196 of the Companies Act 2013, right. And as far as the manager's role is concerned, I would direct you to read this particular decision. It is pretty interesting decision, CIT Kerala versus Alagappa Textiles, AIR 1980, Supreme Court 235, that in fact this Supreme Court decision in detail discusses this concept of the manager. And section 2 subclause 53 of the Companies Act 2013 defines manager, and that is what we have seen the definition right now, and three important points which must be considered as far as the definition of manager is concerned. Now let us come down to another term, that is called managing director. Now this managing director is an important term, and here we need to distinguish it with the manager. And here if you see, it says a director who is entrusted with substantial powers of management of the affairs of a company by virtue of what? By virtue of three things. One, either the same thing is mentioned in the articles of association of a company, or by way of an agreement with the company, or a resolution passed to this regard in a general meeting by the board of directors or by its board of directors through authorization through general meetings. So these are the three modes by which a director can be become a managing director. But here it is important to note that the managing director is not acting under the supervision or control of board of directors. He is independent in this regard. That is what we saw in case of manager. He has to work under the superintendence, control and supervision of the board of directors. Secondly, the managing director holds the position by virtue of being a director. So if he is not a director, then he cannot be a managing director. But in case of manager, it is not like that. In case of manager, he holds the position in his own right as an appointed person as a manager, right. And while a managing director essentially has to be director before, whereas manager can continue to be a manager whether or not he holds the office of a director. That is what is the distinction I made just now. Now let us come down to the whole time director. Now section 2 subclause 94 of the Companies Act 2013 defines whole time director, and it says it includes a director in the whole time employment of a company, and it may be noted that the director may be appointed as a chief executive officer, manager, company secretary or chief financial officer if so provided in the articles of association of a company, and would then be treated as the whole time director. So basically whole time director means a person or a director who is in the whole time employment of a company. He has to devote full time to the company, and he can be designated, he can be appointed as chief executive officer, a manager, a company secretary or chief financial officer. So this is what is about whole time director. Now there is a concept of company secretary, and if we see, the company secretary is a compulsory requirement, as we saw in the previous slide, for certain companies. And company secretary is defined if CS is appointed by a company to perform the functions of a company secretary under the Companies Act, and every listed company and others having a paid up capital of 5 crores or more will have to appoint a company secretary. That is what we have seen previously. And though the secretary's duties are largely of a ministerial or administrative nature, we must be knowing about the company secretary's duty, it plays a very important role in corporate governance. Corporate governance basically means, that you have a proper accounting and accountability towards the shareholders, and this company secretary is defined in section 224, and this draws the definition from the Company Secretaries Act, and which means a person who is a member of the Institute of Company Secretaries of India. So he is a company secretary basically. And then there is a term called CFO, that is Chief Financial Officer, and it is a very important term defined in section 219 of the Companies Act. And if you see, CFO means a person appointed as the Chief Financial Officer of a company. So here you can make a distinction between CFO and CEO. In CEO we saw he is a designated person, designated officer of a company, whereas CFO is appointed as Chief Financial Officer of a company. So he is an officer who is appointed, he is not just designated like CEO. Similarly, this is a new definition which is provided under the Companies Act and suggests that CFO will be in full charge of all financial and accounting aspects of a company, though not specifically mentioned under the definition. So basically what has happened is, you have seen a lot of frauds happening like Satyam and all sort of frauds, and there were charges that the financial system were not in place, or checks and balances are required, and that is why I believe this CFO definition has been introduced, and it calls for an appointment of a CFO who has the responsibility of taking care of the accounting aspects of the company, right? And then there is a ancillary definition, senior management. This is also defined under the Companies Act, and if you see this expression, senior management has been defined to mean personnel of a company who are members of its core management team. So it basically says core management team. Now what is core management team? This does not include board of directors, because board of directors is excluding, that is the policy making body of a company. So it comprises of all members of the management, just one level below the executive directors. So that is basically, these are all functional heads who are there and who will be heading the functional units of, or you can say SBUs of the company, and they will be dealing with the management, core management of the company. So these are the terminologies, and this is what are important types of terminologies which we see. Now let us come down to types of directors. Now section 149 of the Companies Act says company needs to have a board of directors. Now which are they? That board of directors, generally the composition of the board of directors includes executive and non-executive directors. We will see what is the distinction between executive and non-executive directors. Now the differentiation which stems between the executive and non-executive directors is by way of corporate governance principles. If you recollect, the executive and non-executive directors were not exactly defined under the Companies Act. They take their particular definition, or this concept has an emergence from corporate governance principles, wherein they say that the management of the company must have at least 50% of the board of members who are non-executive, means they are not part of the day-to-day activities or policy making of a company. So they cannot be whole-time directors, they cannot be managers, they cannot be designated CEOs, because these are the people who are managing the affairs of a company, and if they sit in the board, they would not give an independent view or independent version of that particular decision, right? So they will always support and defend their decisions, even wrong ones, which they would have done for the company, and that is why the representation in the board would not be fair, and that is why where we say shareholders democracy or democracy in the board, because company is an independent entity, and this board of directors is the mind and will of the company, and that has to be independent, right? And that is why it is a requirement that 50% of the board must comprise of non-executive directors. This was under clause 49 of the listing agreement previously, but now what has happened is listing agreement has now been replaced with SEBI regulations, and this SEBI listing obligations and disclosure requirement actually talks about listing regulations, and regulation 17 provides for the board of directors, which mandates the similar thing, that is 50% of the board must comprise of non-executive directors. You would be aware about the number of directorship which company must have, and minimum and maximum numbers. So as per the types of companies, one person company, there is one minimum director and maximum can be 15. Similarly, for private company, there must be minimum 2 directors and maximum 15. And for public company, minimum is 3 directors and maximum can be 15. And in case of producer companies, which is an interesting addition in the Companies Act 2013, though not addition we can say, this has been actually taken from 1956 Act and reintroduced into the 2013 Act exactly. Must have a minimum of 5 directors and maximum of 15 directors. Now here these directorship can be increased more than 15 if they want, but for that they have to pass a special resolution, and by way of that only it can be increased, right. So these are the types of directors which we are talking about. Now let us exactly talk about different terms which are used in context of types of directors. Now to begin with, let us come down to executive and non-executive directors. I have talked about this a bit briefly in the previous slide. Now let us talk about it in detail. It says the term executive director has been defined to mean a whole-time director as per the company's specification of definition detail rules 2014. So who is the executive director? Executive director means a whole-time director. And who is a whole-time director? We have seen the definition previously, right? That he is a director who is in the whole-time employment of a company. So basically executive directors in whole-time employment of a company. Now the difference between the executive and non-executive director lies in their being internal and external to the organization and their involvement in day-to-day management of the company, and that is where I drew the distinction upon. And as per the Kumar Mangalam Birla Committee report on corporate governance, this was one of the important reports which laid down the foundations for corporate governance. We see the executive directors like director finance, director personnel are involved in day-to-day management of the companies. The non-executive directors bring external and wider perspective and independence to the decision making, and that is where we say the difference between executive and non-executive directors. Chairman of the board always needs to be a non-executive director, but again there is a composition thing here. So if it is 50%, 50%, 50% are executive and 50% are non-executive, then chairman of the board needs to be a non-executive. But if it is 2/3 composition is executive, non-executive, and 1/3 is non-executive, executive, then in that particular situation chairman can be a non-executive. So it depends upon the composition. Idea is that there should be ideal balance between the executive and non-executive directors.